Today on CityCast Las Vegas, we're diving into the latest on the Tupac murder trial. Pete Christiansen, founding partner and lead trial attorney at Christiansen Trial Lawyers, helps us dig into the key elements of the case and where it's going next. It's Monday, August 24th. I'm Jesse Merrick, and here's what Las Vegas is talking about. Pete, how's it going? Thanks for joining us today.
I'm great. How are you?
Not too bad. Let's dive right into it. We're about a week into this trial. What do you think is the most important takeaway from the Tupac murder trial of how it's unfolding thus far?
Well, I think today's going to be the big day for the prosecution. They start getting into the defendant's statements, which is the entire case. It's very unique insofar as it's not a case about fingerprints or DNA. The entire case, the entire investigation is built around Mr. Davis's prior statements, from his immunity statement to his interviews to his book. So his own words will either damn him or let him free.
Yeah, that whole thing is interesting because it just seems like the whole deal relies on Davis being proven as a liar. Like, I think the defense even put up a slide that literally just said bullshit and said that he's known for doing these type of things. How wild is that? That like this whole case seems to be riding on him being a liar, or at least an embellisher.
Well, I mean, I think it's the best defense, right? I mean, if the whole case, if the entire prosecution case is based upon his veracity, the defendant's veracity, whether he was honest or dishonest in his prior statements, then your defense gets to be like, that's all they've got. They've got a bunch of statements from decades ago. I think the first one is 2008, where he's trying to walk his way out of a case and a proffer agreement with different law enforcement, and then interviews he's doing to gain publicity or notoriety. So while it may be wild on first blush, when the case is all about your client's statement, you probably should make your client's statement not too reliable.
Yeah. Is that like, is it strange, I guess, though, for it to be reliant on the defense's statements versus like actual evidence? Like, is that a very common thing that we see?
Very uncommon. So in 30 years of practice in law and more than 100 criminal jury trials, I've never had a case where it's just the defendant's statement without any physical corroborating evidence whatsoever. So I think what you'll see, and what you have seen thus far, is the prosecutor is trying to take little pieces from witnesses that they do have that can't identify Mr. Davis in particular, but they can say, for example, like one of the first women that testified said, hey, I saw Tupac catcalling with some witnesses on the corner of Flamingo and Koval. And that is a piece of all the statements that Davis has given. He says the same thing, that that's where things kicked off, at that location. So you kind of use what you can to corroborate it.
Yeah, you're just kind of piecing together those different details. And as you alluded to, we've heard from a lot of the witnesses here. What were some of the things that stood out to you that we've heard from the witnesses thus far?
I mean, thus far, you just heard a bunch of corroborators.
Yeah.
So people that are saying, like, for example, the police officer that responds to the shooting in 1996 and rides in the ambulance with the victim, right? And the exchange between the victim and police officer about who did it. And Mr. Shakur saying, don't you worry about it. We're going to take care of this ourselves. So that's really all you've got.
Also, too, it's like, apparently there's like hours of video from the prosecutors before they go back to the testimony from Davis. How interesting is that? Like, is that a common thing that you're seeing that much video, or is it just because this was such a high profile case?
In this day and age, there's always video. I mean, from 2006, it's probably far more unusual. So because of the high profile nature of the case and, the documentaries that have been done, from the 50 Cent documentary to the BET stuff that was done for Death Row with Death Row back in 2008 or 9, there's tons of video, including tons made by the defendant.
Prosecutors don't necessarily have to prove that like he was the shooter in this, right? They're trying to go for the murder conviction. That is, like, they basically just have to prove that like he orchestrated it, right? Like give us the details on how that matters.
Sure, he's not charged as a shooter. So they specifically told the jury he's not the shooter. He's charged under a criminal theory of liability called aiding and abetting or conspiracy, which means, you're helping somebody else, or you have an agreement to do something with somebody else. Somebody else, according to the evidence in the case thus far, is Mr. Davis's nephew, who got beat up that night after the Tyson fight at the MGM, and allegedly, is the guy that pulled the trigger. He's deceased, and so it's really comes back again to the defendant's statement and whether the 3 or 4 times that he's made statements, self categorizing himself as a shot caller being slur or gang term for the boss. When he hands the gun over the back seat, is that an agreement under Nevada law? And there's cases that talk about you have to have the specific intent to commit the crime that the shooter commits, as opposed to just generally know what he's going to do. Did you think he was going to shoot or fire the gun into the car? And they don't, they've got the victim's car, but they don't have the gun. They don't have the
Yeah.
defendant's car, the car the defendants were in. So, they're totally reliant upon jury instructions and theories of liability and the defendant's own statement.
The following is a paid political advertisement paid for by the committee to elect Alex Quag.
Hi, CityCast listeners. I'm Alex Quag, and I'm running for Clark County District Court Judge, Department 29. Southern Nevada is my home. I graduated from El Dorado High School and UNLV. From my first job to now raising my family, this community has shaped who I am. That's why public service is personal to me. I've spent my career serving on all sides of our justice system, representing service members in the Army, working as a prosecutor, and seeing how courtroom decisions ripple through people's lives and through our community. That's a responsibility I never take lightly. Clark County deserves judges who bring experience, dignity, and respect to every person who enters the courtroom. I'm proud to have earned their support of prosecutors, defense attorneys, law enforcement, labor unions, veterans organizations, and many others across our community. From JAG to judge, I'd be honored to earn your vote. I'm Alex Quag, running for Clark County District Court, Department 29. Learn more at electalexquag.com.
Paid for by the committee to elect Alex Quag. CityCast does not endorse candidates for office.
It's been 30 years since Tupac's murder. You mentioned a couple of things that they don't have over that time, and I guess a lot of that has probably gone into why this case has stalled so much over the years. But can you lay out a lot of the reasons why that would be the case in 30 years of that this has kind of just fallen through and why it's now just picking back up again?
Any case that gets older typically gets cold, right? The witnesses' memories don't get better over time, and in any case. And in this case, it was very high profile. Allegedly, it stemmed from, at least in part, a dispute between two rival gangs who, by definition or membership therein, don't cooperate with law enforcement. And so, inherently it would have been difficult. Then time passes. The supplier of the gun is deceased. The shooter is deceased. The victim is deceased. Suge Knight, who's in the front seat driving, doesn't cooperate. And the only really facts that change are just the defendant decided to start talking about it, and sort of in violation of Gang 101. Nobody talks, everybody walks is the normal rule. And he decided to talk about it over and over and over, and that's what got him charged.
Yeah. And the thing that's wild too is I know one of the witnesses said, laid out kind of what she saw, and she was like, but snitches get stitches, so I didn't see anything or something like that. And I feel like, as somebody involved in the case, that's got to be super frustrating, right? To kind of have to work around that.
Law enforcement would tell you it's always very frustrating to have non-cooperative folks, and they're out there trying to piece together who hurt somebody and why, and get evidence from it. And you got people that just essentially live by the code of the street will take care of it. In other words, that's what Tupac told the cop on the way to the hospital. Is he wanted to know who did it, the officer, and the answer was, "Don't you worry about it. We'll take care of this."
Yeah, that's the wild thing. The guy that just got shot saying nah, we got this covered, man. We're not going to talk. It's just crazy how quiet everybody is on all factors of this, except for Davis, the guy who now is kind of ratted on himself in a sense. But just in terms of, and you kind of laid it out a bit there, but 30 years, any case, forget with a gang, affiliation being involved in all of it and them not talking for those reasons. What are some of the things unique to a case 3 decades after the fact that could make it so difficult for both sides in this?
Really, just it's time. Generally speaking, in a case, father time gets us all. Witnesses live and die and forget and move on in life, get in trouble. 30 years is a lot of time for people to go back and remember, hey, on a specific night in 1996, what was I doing? Where was I at? And what did I see? And truthfully, in 2026, did you really see what you think you saw? Or have you read a couple of stories about it, and now you're just conforming your memory to what you read? And who gets to that witness first? Whether the prosecutors, investigators, the defense investigators, oftentimes can color, not intentionally, but just as a matter of the human experience. You can color a witness's testimony based upon how you give them the information that you want them to talk about that was 30 years old.
Do you feel it makes it easier on the defense, like with this much time having passed, or easier on the prosecution? I would imagine probably the defense, right?
I would usually tell you that time is a defendant's friend. Time between a crime and a trial lends itself to the benefit of the defendant. This is a super different case insofar as all of the evidence, not all, but the overwhelming majority of the evidence stems from the defendant's own mouth. And so it cuts both ways, I guess, is the answer to your question. The prosecutor's got stuff that's 30 years old. The only thing they got that's fresher than the crime scene is the defendant's 4 different statements, from his book to his interview to his BET stuff to his proffer agreement. And then as the defendant, you normally would get to stand up and say, I don't have a stitch of evidence, no fingerprints, no DNA, no eyewitnesses, no nothing. And now you got the unenviable task of trying to, as you said at the outset, call your own client a liar.
Yeah, and I guess to that point too, like we talked about how weird it is that they're trying to prove him a liar, but the fact that like somebody wrote a book about this thing and that's what kind of kicked things back into gear again. Like, do you know of another case or another high profile case where like somebody's own memoir, it kind of kickstarted things again after it had stalled?
Sure. There's the Robert Durst case that has some eerie similarities, and that is the wealthy gentleman that gets a hung jury the first time he goes to trial for murdering, a significant other. Second time, prior to the second trial, he's doing, I believe it was an HBO interview, and not on what was aired for HBO, but on camera, on stuff that didn't make it to the special. Somebody's like making small talk with the guy, and he says something along the lines of, well, yeah, I got away with it. And that's ultimately like the key piece of evidence that they used to change the setup for him, and they got a conviction based on it.
Yeah, the one thing I learned very early on in my career in journalism, that if you're on camera, expect the mic is always hot. You can't, whether it makes it in the doc or not. Like, that's wild to say something like that. And I guess like we talk about the book being such a big part of this. In this case in particular, like, do we expect any new information to come out, or is it just like all the stuff happened then? Like, how is the process of presenting new information brought along throughout this type of thing?
You would expect that both sides, both of the parties that are in the trial, have all the information. There's really no surprises. Us folks that are looking at it from the outside may think, something's a surprise, or we haven't heard of this particular piece of tape or whatever. Maybe there's a Durst piece, that didn't get broadcast on the BET Awards or whatever the heck that was with Death Row. But for the most part, in a trial like this, the prosecutor and the defense are playing from the same deck of cards.
Mm-hmm. And you mentioned this earlier, and I just want to circle back to it, that like the proffer agreement and the fact that the judge is allowing, some statements from that to be used as evidence in this. How unique is that?
Super unique from the standpoint that most of the time the proffer agreements we run into here in Las Vegas are from Las Vegas law enforcement, or once in a while from the federal law enforcement, but some ties to a Las Vegas act. I mean, this was a completely unrelated investigation into drugs in South Los Angeles that, in an effort to get himself a more favorable resolution, Mr. Davis wanted to talk confidentially with Los Angeles law enforcement with the Tupac murder. And, the agreement is typically the Los Angeles law enforcement and Mr. Davis, they're the parties to the contract. They won't talk about it. It's confidential. It's not to be used against the other. And had it just stayed there, likely this case would have never been brought. But then what happens is Davis gives an interview about his proffer agreement, which blows up his end of requiring it to be kept confidential. Then he goes on TV and talks about it some more, and then writes a book about it, all the time talking about things, including what he said in the proffer agreement. And so my understanding of the judge's rationale was like, if there was an agreement to keep things that occurred in that proffer confidential, Mr. Davis violated it by discussing what he said in the proffer agreement. And I think the other end of her legal analysis was the state of Nevada wasn't a party to the proffer agreement. The state of Nevada obtained the information in the proffer agreement from Mr. Davis. So I don't know how I think the judge ruled that he probably didn't have much room to complain about a proffer agreement that he brought to the attention of everybody else.
Gotcha. Almost like an NDA that you go and talk about on video, then yeah, like it all
Great.
gets.
Yeah, great analogy. I mean, you got an NDA that you say, I'm not allowed to talk about this allegation I made or somebody made against me, and then you go give an interview about it. Well, you just broke the NDA and you opened yourself back up to civil liability.
The way this whole thing is unfolded with him continuing to talk when again the street code is snitches get stitches, but he keeps snitching on himself throughout this process. Just wild to me.
It's a super unique case, and how each side spins those four statements will, I think, determine the outcome of the trial.
The following is a paid political advertisement paid for by the committee to elect Alex Quag.
Hi, CityCast listeners. I'm Alex Quag, and I'm running for Clark County District Court Judge, Department 29. Southern Nevada is my home. I graduated from El Dorado High School and UNLV. From my first job to now raising my family, this community has shaped who I am. That's why public service is personal to me. I've spent my career serving on all sides of our justice system, representing service members in the Army, working as a prosecutor, and seeing how courtroom decisions ripple through people's lives and through our community. That's a responsibility I never take lightly. Clark County deserves judges who bring experience, dignity, and respect to every person who enters the courtroom. I'm proud to have earned their support of prosecutors, defense attorneys, law enforcement, labor unions, veterans organizations, and many others across our community. From JAG to judge, I'd be honored to earn your vote. I'm Alex Quag, running for Clark County District Court, Department 29. Learn more at electalexquag.com.
Paid for by the committee to elect Alex Quag. CityCast does not endorse candidates for office.
And so as this thing does now bleed into this week, what are you really going to be paying attention to?
To me, the key in the case is, what can the prosecutors independently corroborate from Mr. Davis's statements? If they're just statements of puffing, to use a term like he's just kind of bullshit, to use Mr. Samp's term, that's one thing. But usually somebody that's puffing doesn't tell the same yarn or weave the same like bullshit story exactly the same time and time again. Typically those stories change. I mean, the one thing that usually stays consistent is the truth. And I think it will be interesting to see what the prosecutors can bring in from outside witnesses to say, like, there was some catcalling in a car with Tupac and Suge Knight in it on the corner of Koval and Flamingo in 2006 between women and Tupac. One of their first witnesses was one of those women that said, yeah, that was us. That was where it was. And to me, that independently corroborates the veracity of the statement of Keefe D, because that's where he said things kicked off. And so I think you'll see the prosecution try to weave into Mr. Davis's own multiple statements just outside factors that corroborate that he was telling the truth when he made this statement, and that he was the shot caller, and that he knew when he handed the gun to his nephew, the nephew was going to shoot at or into the car containing the two humans that got shot.
And all of this, too, it's kind of interesting because Davis even threw Diddy's name into the mix here now, saying that he was the one that ordered it all. How does all that factor into this, you think?
From a media standpoint, it's interesting for a big story because it's famous people, Diddy and Tupac and other stuff. If I'm the prosecutor, I want to keep it simple, stupid. That's a pretty number one rule of trial is keep it very simple. I would not weave in any of this Piru Bloods versus South Compton Crips, gang war. I mean, that just gives you a whole bunch of alternative suspects, right? Now, if you're the defense, you surely want to say this was way bigger than Keefe D. There was gangs, two gangs, rival gangs. They hated each other. One was for Death Row and one was for Diddy's, music company. And it was Tupac versus the other rappers. And so it just creates little shiny things for the jury to look at that aren't your client.
So essentially, kind of what you're saying is like to almost like, I don't know if this is the right way to say it, but to kind of confuse the jury and overwhelm them with so much information from other sources, right?
Yeah. I mean, you're offering them alternative suspects, people that had motive, opportunity to do what occurred. I mean, if this wasn't Tupac and wasn't Suge Knight and driving that vehicle that got shot into that night, this would probably categorize as just a gang drive-by. They'd be focused on the gangs as opposed to, other things. But that circles back to become one of Mr. Davis's problems, right? He's a self-admitted Compton Crip. which the prosecutors, depending on how much the defense wants to make hay of gang rivalry, like that cuts both ways too. Like most cards in a trial, like they're just pieces of evidence depend on how you spin on them. Who else with better motive than a Compton Crip who didn't like death row, who was on Diddy's side, connected to the Zip character from Brooklyn, the gangster that allegedly supplied the gun? You almost play into the prosecutor's hand. So it's all about how you spin it in front of those 12 people that are going to have to decide one way or another. Did the state meet its burden?
And so, like, as the jury kind of goes through and absorbs all this stuff, like, how do you think they will respond to a lot of the stuff that's being thrown at them here?
None of us were in there to see who got picked as jurors. What type of humans? Do you have 12 nurses, 12 teachers, 12 people that work in the gaming industry? Who in that jury knows anything about death row records? I mean, those of us that like that music or around that genre know something about it. I mean, you saw, and it was widely reported in the first week, everybody was amazed that handfuls of jurors had never heard of Tupac or Diddy or death row records. One lady said, "I like country music." That's it.
I didn't think about that when you realize like 30 years has passed. So there may be people that have no understanding of all of that. Like that's a whole nother element that comes into it because people that are under the age of 30 can be involved in this.
Correct. They weren't alive when it happened, but that's the jury instruction. I mean, in a ivory tower law school analysis, that's what everybody wants in a trial, right? 12 people that are wholly unfamiliar with the lawyers, the parties, or the facts. And
definitely.
The judge, every single time that jury takes a break to go to the bathroom, to go home at night, the judge reads them an admonition telling them you're not supposed to consider anything except for what occurs in the four walls of this courtroom, not even what you see in the hallway. So, I mean, that by definition is what a jury should look like and how they should act. And it'll be interesting to see and learn after the fact who both sides chose as jurors and whether they were able to do that or they brought some of their life experience with them.
And I would imagine too, like just in a case like this that is so high profile, to avoid all of that, like as someone being wrapped up in this case, like if you had to put yourself in their shoes, I'd imagine it's very difficult to stop the jury from going and reading up on the past of it or just being involved somewhere because there's so much media, whether it's books, media appearances, all that stuff that they could be taking in, right?
For sure they could. I mean, the judge admonishes them literally every time they stand up to leave the courtroom that they can't do that. There have been plenty of cases where us lawyers have caught jurors doing it. In one murder case, some guy decided to go conduct an experiment about how the murder took place. He used a coconut and a boulder as for the person's head, and he came back in the next day and told the rest of the jury, "Look, I did this experiment, and you really can't break a coconut." So I don't think that was a mistrial. The whole case was for a waste and started all over.
Man, yeah. So that's a whole another can of worms, I guess, huh?
Right. In today's day and age, every one of those jurors has social media accounts, and you can bet that both the state and the defense are monitoring all their social media stuff to see who's posting, who's searching what, to the extent you can see those things. And that causes mistrials all the time. Jurors get told, don't, look at that stuff. Don't post about the case. You're not supposed to talk about the case except that you're in a criminal trial in front of Judge Kearney and the 8th Judicial District Court. And folks get caught doing it and kicked off of jury duty like every single week in Clark County.
I can imagine. And so as we get ready to close here, just in terms of what people can expect time-wise from this, how long do you expect a case like this to take?
I mean, it's just witness dependent. My bet is the prosecutors circle towards the end of their trial, the end of their evidence first of the week. And the defense will have, they've got the big decision. Do you put the defendant on the stand or do you not put the defendant on the stand? And that could take days, right? The defendant getting up and telling his story, the direct examination will be hours, and then cross-examination. I mean, he's given a statement 4 different times that I know of. And so now he's going to have a new story, right? To say that I wasn't responsible and I was just kind of making up that other stuff. I mean, that lends itself to a really effective cross-examination about, the truth is the truth, no matter the point in time you're asked the question or the person posing it to you. And he's going to have to find a way to weave himself through that needle.
Yeah, and I'm sure that's something that'll take plenty of time in order to do. So buckle up, everybody. This obviously doesn't seem like it's going anywhere anytime soon, but definitely makes for interesting conversation here on this podcast and for everybody out there following it from afar as well. Pete, thank you so much for the time. This was a really interesting conversation.
Thank you. Thanks for having me.
That's all for today here on CityCast Las Vegas. If you enjoyed the show, why not tell a friend? Rate the show, leave us a review, and subscribe to our free morning newsletter as well. And don't forget, you can support this show and get great perks by becoming a CityCast Las Vegas neighbor at membership.citycast.fm/Las Vegas. We'll be back tomorrow morning with more news from around the city. Until then, though, take care.